Counsel, I've reached a decision on the allocation based upon the expert testimony. It is going to be my ruling here, which I'll reduce to written order, but I wanted to let you know verbally right away so that you can continue to proceed to prepare for trial on the damages. But I have been persuaded by the testimony of the plaintiff's expert on the question of causation and allocation of liability for the terrible accident here. As the comments indicate, and really testimony of the defense experts were contradictory, and it all seemed quite clear that the actual manufacturer of the self-driving car was not the one who had negligent equipment. It was not really the cause here. The cause was primarily shared between Navi Auto, the internal systems, and its data provider, GeoMaps. The error in code and all of the data analyzed topographically, and the mathematics clearly show it was those two. With a little bit, the sensor company did have some error as well, which I'll lay out in my written order. But the primary allocation here is going to be Navicorp 65% on the comparative negligence, GeoMaps 30%, and sensor company 5%. And as you know, under Florida law, this is comparative negligence. So this is the total liability must be paid by these individual companies. We can have a trial, and we're ready to do that for the jury to determine the total amount of damages that'll be divided up according to these proportions. Or I would urge counsel to continue settlement discussions to see if they can't agree on that. Otherwise, we will convene again on Monday morning to begin picking a jury for the second phase of this proceeding and the trial on the damages. Thank you, counsel.